And beyond just the impact on the individual litigant who's unrepresented, does it also impact the courts? Are there additional delays? You mentioned the court staff that get or ask questions. Does it actually increase costs to the court system and use up resources that would not be needed if those litigants were represented?
Yeah, I mean, I would say the cases in which litigants are self-represented become more labor-intensive for the court, for the judge, for the judge's staff, for the clerk's office, for the court personnel. So, yes, I would agree with that very much.
And to go to the defense side, I know and I agree with my colleague that there is a need for increased services for defendants, indigent defendants, particularly in first appearances that go beyond the Harrell decision. And I understand that the Indigent Legal Services Board has asked for increased resources to be able to address those needs, and I think that is something, obviously, that personally I would support, and I think other members also. Can I just want to ask you a question about the staffing? You mentioned that there's been a reduction of 2,000 non-judicial employees, and I think you mentioned it was 12%. Is that correct?
Since 2009, that was the high-level mark for us. We have 2,000 fewer employees since that year.
And I probably should know the answer, but perhaps do you know how that compares to state agencies?
The executive branch?
Oh.
Yeah, for us, it's a 12% increase in the court system. The roughly 2,000 fewer employees. In the executive branch, depending on how you define the executive branch, but if you include CUNY and SUNY, the executive branch employment level since 2009 has dropped between 8 and 8.5%. So our employment level has declined more than the executive branch.
Thank you on that. I think for the moment that's all the questions, Mr. Chairman.
Thank you very much. Our next speaker is Senator Michael Nozzolio, who is chair of the Codes Committee.
Good morning, Judge Marks.
Good morning.
We're used to seeing Judge Prudenti in that chair. I don't see much of a resemblance, but at least in outward appearances, she certainly has big shoes to fill, and I wish you all the luck in this endeavor.
Thank you.
I want to follow up on the questioning that's already occurred. Senator Bonasek and I have discussed this issue a number of times over the last few weeks, and one of the things about Judge Prudenti is that she always looked for creative ways to solve problems. That in large part because of the creativity she exhibited, the CASA program was revived when budgetary axes had to fall, and Senator Bonasek, myself, and others worked very closely with her to restore that program. I share your admiration for civil legal services. I think it's a great program. I probably, in the course of my service, have had many more requests for legal assistance through the Assembly and Senate offices that I served in than you as a judge would have ever had. Literally hundreds of people have asked it. I have supported, through special grants, civil legal services in the Finger Lakes region. I understand its importance. However, Senator Bonasek, I think, stated it very clearly. We believe we're your partner in the legislature as we try to tackle these budget challenges. The Judicial Pay Commission was a commission established by the legislature because we believe there was a need to have judicial salaries increased, and we look to be a partner with you in the court system in meeting the obligations established by the commission. That's public policy. We need to do that. At the same token, a major increase in the budget from one year to the next, 21%, for, albeit a very noble program, just is not appropriate for this period of time. And that we look to see you develop the creativity that we know you are likely to have in solving this problem. Certainly we understand the time frame, we understand the budgetary restrictions. I think logically, though, to say it saves money for the state, yes, it does, but if that was the case, then we should raise civil legal services to $100 million. We should increase the budget by 75%, 100%, because if we're going to have such a great savings, obviously more would be helpful, but that's not the reality. And it's not a dollar for dollar savings. I want to hear from you in your capacity as leader of the court system. What types of creative solutions are here? Judge Littman spent a lot of time discussing pro bono work, establish requirements for pro bono services for attorneys to be admitted, for attorneys to continue in other services, to achieve the objectives that this body shares in supporting legal services. Yes, an increase could be appropriate. Yes, we need to be partners with you on the salary increases that judges are receiving. But what are you doing to make civil legal services more effective, efficient, and cost effective for the taxpayer?
Well, look, I think your points are well taken, particularly about Judge Prudenti, who was very creative and had to be. I think she served as chief administrative judge through some very difficult years, and hopefully things have gotten better. But you know, I understand necessity can be the mother of invention, and you know, when you're really pressed, you know, you're forced to be creative. And I can promise you that I'll do that as well. I mean, I'll continue that trend. But you know, in the end, our budget situation has been so challenging, you know, for so many years at this point. I mean, we started back in 2011 with a $170 million budget cut. That was followed by a flat budget the following year. And of course, a flat budget is really a negative budget because costs go up, they don't go down. The year after that was another flat budget. And the last 2 years we've received, you know, very modest increases in the range of 2%, which we greatly appreciate. And I'm not being ungrateful about that in the least, don't misunderstand me. But, you know, at some point where costs have been going up and up and up, and which is what they do, you know, you can be creative only so much, and, you know, you run out of ideas at some point. So I can't sit here today and tell you about all the creative ideas that are in my head as to how we'll deal with this if we don't get additional money, because I'm very much hoping that we get additional money. I'm hoping that we can get your support about that. But in the end, frankly, if we don't, and we'll have to prepare for that eventuality, because that's certainly a possibility. And you know, we will find a way to manage this one way or the other. I mean, the courts will remain open. I'm not suggesting in any way at all that we won't continue to keep court houses open and we won't be providing justice to the people of this state. But we're going to have to be very, very creative. I agree with you.
And again, we are not trying to shirk the responsibilities of the legislature one bit. We believe strongly that the issues of judicial salary increases have to be met, can't totally be absorbed within the traditional court budget, judicial budget. But we look to these other expenditures as, so expect you'll have advocates to help in that endeavor. But we want you to also find ways to help the taxpayers who are paying for these bills to find creative ways to stretch, to cut, and to provide the services in less costly ways.
No, and I appreciate that, and I agree with you.
Thank you. And thank you, Madam
Thank you,
Chairman.
Senator. We've been joined by Senator Phil Boyle and Senator Daniel Squadron.
Mr. Montesano.
Thank you, Mr. Chairman. Good morning, Judge.
Good morning.
Judge, you, in your response to the different questions and comments you made, you know, what I'm concerned about is, and I'll address the indigent legal services in a moment for the civil part, but, you know, as a practicing attorney, I get in and out of the courts quite a bit in Nassau County, and I can't begin to tell you the decimation of our court system in Nassau County over the last several years. In our surrogates court alone, we lost approximately 35 operational staff, which resulted in limited cashier hours, limited record room access, and some of those things have been cured a little bit down the line. In our Supreme Court, many parts are down on a daily basis because there's no court officers or clerks to staff them. So while we give this free indigent legal services in the civil parts, it's all well good when the litigant comes in with the free attorney, but there's no courtroom to appear in. We have one we have one clerk covering 3 parts. So they run from one courtroom to the next, or they're handling 3 calendars at the same time. So when you indicated that a lot of these costs that OCA is incurring over the last several years has to do with personnel and salaries, when many of the, and I'm not going to put myself in the middle of contract negotiations, but many of those unions that you're talking about, court officers and clerks specifically, they've gotten 0 contracts over the last several years. So I don't understand where there's an increase in salaries, because they haven't gotten anything. So yet there's a $15 million bump in the free civil legal services. So I'd like to get an idea from you, which driven that uptick to justify.
I'm sorry, which what?
What is driving the uptick in the civil legal services to warrant another $15 million?
Well, we don't have a contract with the Nassau Court Employees Union. That's correct. Unfortunately, we don't. We would like to have a contract with them. We have 12 labor unions in the court system, and at the moment we have contracts with 8 of the 12. So with respect to the employees in those unions, they've received salary increases, modest salary increases over the last couple of years, and that's the reason for our increasing salary costs. It's we have contracts with 2/3 of our unions, but not in Nassau, unfortunately, and hopefully we will reach agreement with them shortly. But yes, you know, what you're describing in the courts in Nassau, there have been consequences of our reduced staffing levels. And I'm sure you've accurately described some of those, you know, based on your firsthand experience. And, you know, that's my concern, is that and I think there have been improvements over the last year or two. And I very much want to be able to continue that trend and be able to improve from year to year, which is why I'm very much arguing for asking you and pleading with you to provide this additional money that I firmly believe we need to continue improvement and to mitigate some of the problems that you're describing in the courts in Nassau County, for example.
And Judge, just to go in a different direction for a second, the bail system, I know that a process has been instituted. I think it started in the city, that when bail is set on a defendant, it could go to another judge of the same court who's going to review the judge's bail. Now, it just seems odd to me that a judge of the same jurisdiction in the same court is acting as an appellate review of a judge's bail. Legally, how did that come about?
Let me explain it to you. It's just in New York City, by the way, not in your district. There's a review, if it's requested by the defendant or the defense counsel, there's review not to a judge of the same jurisdiction, but to a judge in the Supreme Court. And this is for misdemeanor cases only the low-level offenses. And it's perfectly authorized under the law. It's Section 530.30 of the Criminal Procedure Law. If you take a look at it, gives Supreme Court the authority, upon an application by the defendant, to review bail that was set by the lower court judge. So it was based on that statutory authority.
Thank you, Judge. And just a last follow-up on my question before. Can you give us just a quick overview of the justification for the $15 million increase on the Indigent Legal Fund? Which driven that uptick in that cost over last year?
The justification for it is it's the last installment of a 5-6-year plan to reach $100 million for civil legal services in this state, which, by the way, doesn't solve the problem of the justice gap. There will still be multitudes of people who do not have lawyers and won't have lawyers, but because of this money, for example, in this fiscal year, there'll be over 450,000 people who have lawyers because of the money that we're providing. And this would be the very last installment that will fulfill the goal that was set 5-6 years ago to reach $100 million for civil legal services. And we were able to add money to it in more difficult budget years, more difficult fiscal years than this year. So we feel that it's very important, that it benefits hundreds of thousands of people who need help throughout the state. It levels the playing field in the courts, and we feel it's very important, and it's why we're urging the legislature to provide that funding.
Thank you, Judge. Thank you, Chairman.
Thank you, Assemblyman. Our next speaker is Senator Diane Savino.
Thank you, Senator Young. Good morning, Judge Marks.
Good morning.
I'm happy to see in your testimony that you guys are actually asking for more money. If you recall, at Judge DeFiore's nomination and her confirmation on the Senate floor, I mentioned the fact that she's inheriting a court system that is overburdened in many ways and has suffered from a shortage of resources. In fact, Sunday's New York Times detailed the long slog through the court system. They took one particular young man who was injured, and it took several months for cases to move that should have taken much less time. So we know that our courts are overburdened. But I have a question. I know you've had several collective bargaining units in the court system. Are all of them now settled? Have you settled all their contracts?
No. I was saying before, we have 12 unions in the court system. We have contracts with 8 of the 12, and we're eager to reach agreement with the remaining 4.
Do you feel that the proposed budget by the governor is sufficient to meet the financial settlements of those contracts?
It would be very difficult.
It would be very difficult.
Yes, yes.
And in addition, there was a lawsuit brought against the courts by the Court Officers Association that triggered a hiring mandate. From what I understand, there was supposed to be 350 court officers hired, 150 have been actually accomplished, and there's another 200 outstanding. Is there sufficient money in your budget to meet that additional hiring?
Well, court officers, we're down, as I was saying before, 12% in our workforce since 2009. We have, court officers have been hit less hard, at least when you look at it today. Statewide, we're about 6.2% fewer court officers than we were in 2009, which is proportionally less than some of the other titles. And in fact, because look, public safety, in the courts, there's really nothing more important than that. People,
no doubt. People
who work in the courts, people who come into the courts have to be secure and safe, and we would never compromise that. And in fact, we're starting a court officer class in our academy, which when we hire court officers, they have to go through the academy, obviously. There's a class of, I think it's 150 recruits starting later this month. Once they're deployed in the courts, when they graduate from the academy, later this year, we'll be down to maybe only 3% or so less, 3% fewer court officers than we had in 2009. So frankly, I'm less concerned about the number of court officers, although it's not perfect, and we do need more court officers, particularly in some parts of the state. But I think we're in better shape with regard to court officers than we are with some of the other titles.
Well, I'm glad to see you feel that way. But again, there's certainly a shortage of court officers, court clerks, court stenographers, and basically courtrooms. I spoke previously about the problem we have in Richmond County. You know, the state created a separate judicial district for Staten Island, Richmond County in 2007. To date, we have yet to receive the 7 judges that we're entitled to. We owe 3 to Brooklyn. You know, we're entitled to 10, judges for the county of Richmond. We don't have them. We have a brand new courthouse that we outgrew already, and this is not your problem. I'm just saying this to make the point that while the discussion today seems to be between civil legal services and judges' salaries, I think it goes beyond that. We still have a court system that is overburdened, under-resourced, regardless of how we decide whether you should get civil legal services or whether judges should get a raise. By the way, I think we should do both. But I think we also need to increase funding to the court system because we're not able to, in my opinion, deliver what Judge DiFiore says is most important to her, the speedy and efficient administration of justice. So I would just hope that while we continue to listen to you today, people take into consideration it shouldn't be just civil legal services versus judges' salaries. It's how do we appropriately fund a court system so that we can meet that mandate of speedy and efficient administration of justice. Thank you, Judge Marks.
Thank you.
Thank you. Assemblyman Lenthal, Chairman Lenthal.
Thank you, Mr. Chairman. And congratulations, Mr. Marks, for your ascendancy to this very good position.
Thank you.
Chief Administrative Judge. I guess I'm a little bit torn because I know that having appeared in court and knowing that judges like I do, and even legislators like I do, that none of us would like to see a wounded warrior not have a lawyer in court at the expense of my not getting a raise or a judge not getting a raise. I would not like to see a homeless person who lost his home because of a bank who foreclosed him illegally. And so I guess I believe that, as Diane Savino said, that we surely have to do both. But I certainly wouldn't advocate for taking money away from legal services and putting additional people out on the street. And since we're going to be in Afghanistan for a while, not having legal representation for the veterans of the United States of America. Actually, I wanted to ask you about raise the age of criminal responsibility because the Chief Judge, as you know, has created an adolescent diversion court part in the adult criminal court in 9 counties, dedicated exclusively to handling cases of 16 and 17-year-olds. And since the governor has, again, talked about this in his State of the State and it's in his budget, might you provide us with an update on the status and operation of these new adolescent diversion court parts?
Well, they're continuing. This was a program that was started by the prior Chief Judge, Judge Littman, at the same time that he called for statutory reform, the legislature raising the age of criminal responsibility, which I think, as we all know, we're one of only 2 states in the country that sets the age of criminal responsibility at 16. And so the adolescent diversion court parts were a complement to the legislative proposal. The legislation is the ultimate solution. But in the meantime, these are court parts that were set up. I think we have 11 of them now throughout the state. They have been successful. They're set up in cooperation with the district attorney's offices in those jurisdictions who have been supportive. They're a limited solution to the problem. I think it's fair to describe it that way. They're mostly dealing with misdemeanors. I think a few may deal with a modest number of nonviolent felonies. But they've been certainly successful. We're continuing them. There's been evaluations done, scholarly evaluations of the results of the adolescent diversion parts, and they've been shown to reduce recidivism for the 16 and 17-year-olds participating in the program. So it's been a successful program, but it's somewhat of a limited program, and we feel, and certainly the new Chief Judge feels that way, that the ultimate solution is to statutorily raise the age of criminal responsibility in New York.
Now, both the Assembly and the executive proposals talk about a large amount of cases being shifted from the criminal part to the family court. And since we're talking about the lack of resources for all the court system, I'm wondering if you believe the necessary resources are available to implement,
Yeah, we've taken the position we could accommodate, there would be more cases in family court. So there wouldn't be more cases overall in the court system. There would be a shift of some cases that are now in the criminal courts to the family court. And family court certainly has challenges. I'm not going to suggest otherwise, but family court does have 25 new judges thanks to the support of the legislature. We have 25 additional judges in family court around the state. So the other thing is when
Has
Judge
that helped?
Lippman,
Has that
pardon me?
helped? 25 additional family court judges?
Absolutely. Yeah, absolutely helps. We were very happy that the legislature approved that 2 years ago. But the number of 16 and 17-year-olds who've been arrested, that number has plummeted over the last half dozen years or so. It's a fraction of what it once was. So there might be a need for some additional resources in family court, but my sense is that it would not be draconian. And so it would be a problem that we would cope with, and if the legislation passed, I think under all the proposals, I know this about the governor's proposal, there would be, the effective date would not be for a year and a half down the road. So there'd be time to prepare for it. There might be some modest additional expense costs for the court, but we feel, and we've thought about this a great deal over recent years, that we would be able to handle that, and it would be a good problem to have. In other words, we view it that way.
Thank you very much.
Okay. Next is Senator Ruth Hassel Thompson, ranker on Judiciary. Just going to make a chair trade.
Thank you, Madam Chair. Good morning, Joe.
Good morning.
I just have a couple of questions. I understand that most of the questions that I had wanted to pose have already been asked of you, so I won't be redundant. But I would like to just ask how, or are you committed to the bail reform process that was begun by Chief Judge Lippman last year? And how soon do you think, if you're committed, that will roll out?
Well, the bail reform process has mostly been put in place. The new chief judge supports it. We're going to continue that. We feel that there are a number of people who are not a threat to anyone, or people who don't have a history of violence, who are detained pending the outcome of the disposition of their case simply because they can't afford to make bail. There are a lot of alternatives that we feel that judges could be using to avoid that situation. We're trying to encourage judges. In the end, it's a judge's decision, in an individual judge's discretion on whether to set bail or not and how much. But we are trying to be supportive of judges and to provide them with sufficient resources and alternative resources so that some people, should be detained who clearly are a threat to society and a threat of committing further violence, but many people are not, and they're sitting in jail awaiting the disposition of their case simply because they don't have the means to make bail, and that's a problem that we're trying to address. There's also a statutory solution which has been proposed, and I think we'll pursue that as well. And I think the new chief judge will want to pursue that as well. But this is a problem that we're committed to addressing and committed to trying to resolve it as best we can.
What have been some of the barriers to getting it resolved?
The statutorily, Well, the proposal that we sent to the legislature a couple of years ago would address, number one, the fact that that in New York, and it's almost kind of completely upside down if you think about it. In New York, judges are not permitted to take risk to public safety into account when they make a bail determination, which doesn't seem to make any sense. We're one of only a few states that prohibits judges from taking that into account. Judges should be able to take that into account so that if there is someone with a real propensity for violence before them, that should be a factor that the judge should consider in setting bail. But on the other hand, we feel that where someone does not present a risk of violence and does not present a risk of failing to return to court if they're released, that there should be a presumption of release without bail. So it sort of addresses two kind of different but in some ways related problems that we feel the legislature should take a careful look at. And both of those problems could be resolved, we feel, in the bill that we presented to the legislature.
I'm confused. I'm confused because if you're saying the bail happens before the case goes to trial, there still is the presumption of innocence. So where the argument that you're raising confuses me tremendously.
Well, there are people who have a history of interaction with the criminal justice system, have had prior cases, and have a history of having been released pending the disposition of their case and not returning to court. And bench warrants get issued, and that's a real problem for the courts. It's a real problem for society when people have a criminal charge against them, presumed innocent, you're absolutely correct, but have a history of not returning to court when they've had a criminal case. So bail, we feel in those instances, is entirely appropriate, where there's a history of not returning to court when they should be doing that. We also feel, and this is the law in the vast majority of states in the country, that in making a bail determination, a judge should be able to take into account whether the person before them is a violent person and may, if released, commit a further act of violence. To us, that seems like a very common sense approach, and an approach that should be reflected in the bail statutes in New York.
Thank you. Just let's go back for a minute to the explanation that you were giving on the implementation of Raise the Age. Answer for me again. How many new parts and attorneys will OCA need in order to fully implement? I know you have, the implementation is not going to occur in 16, but we're also looking at you absorbing a tremendous deficit this year in terms of the new judges that have come on and judge raises and a lot of other issues. I would not like to see any of these issues become a barrier to us implementing this program as we move out. So what would the numbers mean given the financial straits that you find OCA in at this moment?